Senate will come to order. Mr. Schaffler, please call the roll.
Senators Amabile, Baisley, Ball, Benavidez, Bridges, Bright, Carson, Catlin, Cutter, Danielson,
Excused.
Doherty,
Here.
Exum, Frizzell, Gonzalez, Henriksen, Judah, Kip, Kirkmeyer, Kolker, Lindstedt, Liston, Marchman, Mullica, Pelton B, Pelton R, Rich, Roberts, Rodriguez, Simpson, Snyder, Sullivan, Wallace, Weissman, Zamora Wilson. Mr. President.
Let's do this. The morning roll call is 34 present, 0 absent, 1 excused. We have a quorum. Senator Zamora Wilson, would you please lead us in the Pledge of Allegiance?
Colleagues, please join me for the pledge. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Approval of the journal. Senator Kolker.
Thank you, Mr. President. I move that the Senate Journal of Monday, March 23rd, 2026 be approved as corrected by the Secretary.
You've heard the motion. All those in favor say aye. Opposed, no. But the ayes have it. That motion is adopted. Senate Services.
Correctly engrossed, Senate Bill 83 and 122. Correctly revised, House Bill 1039, 1098, 1180, 1189, and 1192. House Joint Resolution 1022. Correctly re-revised, House Bill 1191. Correctly enrolled, Senate Bill 4 and 50.
Committee reports.
Committee on Education, after consideration on the merits, the committee recommends the following. House Bill 1090 be referred to the Committee of the Whole with favorable recommendation and with a recommendation that it be placed on the consent calendar. Committee on Judiciary, after consideration on the merits, the committee recommends the following. House Bill 1232 be amended as follows, and if so amended, be referred to the Committee of the Whole with favorable recommendation.
Consideration of resolutions. Majority Leader Rodriguez, proceed out of order. Resolutions.
Thank you, Mr. President. I move the Senate proceed out of order for consideration of resolutions.
The motion is to proceed out of order for consideration of resolutions. All those in favor say aye. Was there an aye? Oh, okay. Opposed, no. The ayes have it, and that motion is adopted. We will proceed out of order. Consideration of resolutions. Mr. Schaffler, please read the title of SR 004.
Senate Resolution 004 by Senators Judah and Bridges concerning recognition of October 2026 as Conflict Resolution Month in Colorado.
Senator Judah.
Thank you, Mr. President. Members, we are here to introduce Senate Resolution 004 and ask that it be read at length.
And we move it.
Mr. Schaffler.
And we move it.
Very good. Mr. Schaffler, please read SR 004 at length.
Whereas conflict resolution encompasses many forms of responses to differences, such as mediation, arbitration, facilitation, collaborative decision-making, ombudsperson activities, and restorative justice practices, and whereas these conflict resolution processes empower individuals, families, communities, organizations, and businesses to foster communication and design solutions that are acceptable and responsive to the needs and interests of all parties involved. And whereas conflict resolution is taught and practiced by professionals in many school systems and universities throughout Colorado and the world as a peaceful, nonviolent way of resolving disputes. And whereas community-based conflict transformation programs work to strengthen local relationships by fairly and equitably resolving neighborhood and community conflicts and opening dialogues grounded in reason and mutual dignity and respect. And whereas associations of conflict professionals promote peaceful and creative resolutions to disputes, as well as develop proficient conduct standards. And whereas alternative dispute resolution, ADR, and restorative justice practices bring cost and time savings to the handling of disputes in the state court system and cost avoidance to the correction systems. And whereas additional benefits through conflict resolution practices include creative and more durable interest-based resolution, increased satisfaction for the parties who are active participants and ultimate decision makers in the negotiation, and the transformation of personal relationships, thereby decreasing the likelihood of further disputes or strained relations. And whereas the Colorado General Assembly's exemplary collaboration across party lines to enact sound conflict resolution policy has a very real impact on the behaviors of all Coloradans, our economic progress, and community relationships throughout the state. And whereas Governor Jared Polis has proclaimed the month of October to be Conflict Resolution Month in the state of Colorado, now therefore be it resolved by the Senate of the 75th General Assembly of the state of Colorado that we, the members of the Colorado Senate, join the governor in recognizing October as Conflict Resolution Month in Colorado. 2, that we invite Coloradans to create events that celebrate and promote the use of productive conflict transformation and dispute resolution in their communities. 3, that we call upon leaders across the state to use Conflict Resolution Month in Colorado as an occasion to discuss the principles and use the practices of conflict resolution in their homes, schools, neighborhoods, congregations, and workplaces. 4, that we encourage all residents of the state to reflect upon conflicts present in their own lives and to work to resolve those conflicts responsibly and peacefully. 5, that in conjunction with the Conflict Resolution Month in Colorado, we encourage educational programs that emphasize the benefits of facilitative, interest-based, party-centered, and restorative practices. And we hope to bring these benefits to the attention of judges and other officials and staff in the state court system, state executive branch, and local governments throughout Colorado. And 6, that we encourage the participation of judges and other officials and staff in the state judicial branch, state executive branch, and local governments in celebrating and observing Conflict Resolution Month in Colorado. Be it further resolved that copies of this Senate resolution be sent to Governor Jared Polis, Chief Justice Monica M. Marquez, Colorado Supreme Court, Sharon Sturgis, Office of Dispute Resolution in the Colorado Judicial Department, Matt Reed, Colorado Restorative Justice Coordinating Council, and to each member of Colorado's congressional delegation.
Senator Judah.
Thank you, Mr. President. Today on the floor, we welcome and extend our gratitude to those joining us on the Senate floor today who are conflict resolution professionals, conflict facilitators, coaches, consultants, mediators, arbitrators, and restorative justice practitioners. I would also like to note that we have the Honorable Senator Linda Newell here in our presence, who leads a lot of this work. These are the professionals who work behind the scenes as neutral parties to help facilitate resolving, transforming, and healing conflicts through our state. Now more than ever, we need to collectively reaffirm these principles to advance the understanding and use of positive dispute resolution in legislative and community work and our personal lives. Everyone is welcome to join in this effort to foster considerate conscious communication in our homes, workplace, communities, and schools. In 2009, Colorado became the first state in the nation to have its state legislature, via Senator Linda Newell and Governor Bill Ritter, proclaim a whole month dedicated to a peaceful way of managing conflict.
Senator Bridges.
Thank you, Mr. President. This is the group that sends you those books every year, colleagues. The incredible conflict resolution books that end up in your mailbox every summer. I get lots of comments on those from many of you. I don't think all of you are reading them, so next year, make sure you do that. Today, we acknowledge the professionals, and of course, I read them. I deliver them. They're delivered on my behalf. So today we acknowledge the professionals and volunteers behind Conflict Resolution Month in Colorado. For decades, this devoted group has worked tirelessly to inspire Coloradans to solve problems constructively. Through the promotion of various conflict management resources, they have helped empower and educate individuals, families, communities, and organizations like ours to foster communication to find nonviolent and creative solutions to disputes. Coloradans have undeniably benefited from this cost-saving and healing work. We join in recognizing October as Conflict Resolution Month in Colorado and invite you and your constituents across the state to use effective conflict strategies and restorative justice practices in all communities for positive conflict transformation. Thank you, and may we continue to be national leaders in peaceful problem solving and communicating. Friends, please join me in welcoming this group here in the corner and thanking them for all they do for the state.
Welcome. Further discussion. There is further discussion. Senator Gonzalez.
Thank you, Mr. President. I rise in support of this resolution. At a time when trust in our institutions is lower than it ever has been, at a time when we're reckoning with and grappling with the failures of our heroes, the people who we have looked up to and put on pedestals, not only is it important for us to grapple with what does it mean to acknowledge harm, but how do we move towards healing? The work that you do in community and with people who have been engaged in those conflicts matters so deeply. Thank you for your work. It is needed now more than ever. I ask for an aye vote on this resolution.
Very good. Seeing no further discussion, the motion is the adoption of SR 004. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, SR 004 is adopted. Co-sponsors, Senator Bridges.
Thank you, Mr. President. I move that the current roll call be added as co-sponsors, assuming there's no conflict over
Seeing
that motion.
no conflict or objection, I request, and the current roll call will be added as co-sponsors.
Thank you.
Very good. Mr. Schaffler, Mr. Majority Leader.
Thank you, Mr. President. I move to lay over House Joint Resolution 1017 until Monday, March the 30th.
The motion is to lay over HJR 1017 to Monday, March 30th. All those in favor say aye. Opposed, no. The ayes have it. HJR 1017 will lay over until Monday, March 30th. Third reading of bills. Consent calendar. Mr. Schaffler, please read the titles of all the bills on the consent calendar.
House Bill 1180 by Representative Marshall and Gonzalez R. and Senator Henderson concerning the continuation of the Business Intelligence Center Advisory Board and in connection therewith implementing the recommendation of the Department of Regulatory Agencies 2025 Sunset Report by repealing the Advisory Board. House Bill 1189 by Representatives Espinosa and Senator Snyder concerning property held by a community property spouse subject to the Uniform Community Property Disposition at Death Act.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the passage of the two bills on third reading of bills, final passage consent calendar, which are House Bill 1180 and House Bill 1189.
Any discussion on any of the bills? Seeing none. The motion is the passage of all the bills on the third reading of bills consent calendar. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, House Bill 1180 is passed. Co-sponsors. Please add the president by himself. Love you, Senator Henderson. You're welcome. With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, House Bill 1189 is passed. Co-sponsors. Senators Frizzell, Amabile, Judah, Carson, Lindstedt. Please add the president. Mr. Majority Leader for JBC. Oh, I forgot about that. Third reading of the bills, final passage. Mr. Schaffler, please read the title of Senate Bill 66.
Senate Bill 66 by Senators Judah and Carson and Representative Jackson concerning the regulation of compounded weight loss medications that have not been approved by the United States Food and Drug Administration.
Mr. Majority Leader.
Thank you, Mr. President. I move to lay over Senate Bill 66 until Wednesday, March the 25th.
The motion is laid over Senate Bill 66 to Wednesday, March 25th. All those in favor say aye. Opposed, no. The ayes have it. Senate Bill 66 will lay over to Wednesday, March 25th. Mr. Schaffler, please read the title of House Bill 1192.
House Bill 1192 by Representatives Phillips and Barone and Senator Exum concerning restructuring the Homeless Prevention Activities Program.
Senator Exum.
Thank you, Mr. President. I move House Bill 1192 on third reading and final passage.
Further discussion? Seeing none, the motion is the passage of House Bill 1192. Are there any no votes? Senators Zamora Wilson, Frizzell, Baisley, Liston, Pelton R., Carson, Catlin, Pelton B., with a vote of 26 ayes, 8 noes, 0 absent, and 1 excused, House Bill 1192 is passed. Co-sponsors, Senators Marchman. This is for 1192. Wallace, Kipp, Cutter, Benavidez, Gonzalez, Amabile, Mullica, Ball, Judah, Snyder, Colker, Doherty. Please add the president. Mr. Schaffler, please read the title of Senate Bill 122.
Senate Bill 122 by Senators Pelton R. and Roberts and Representatives Winter T. and Lukens concerning liquid fuels and in connection therewith increasing the maximum amount of liability of the Petroleum Storage Tank Fund for individual incidents and allowing the Director of the Division of Oil and Public Safety to adopt a rule or issue policy guidance that provides exceptions to specific requirements established at an ASTM standard for petroleum products.
Senator Roberts.
Thank you, Mr. President. I move Senate Bill 122 on third reading and final passage.
Further discussion? Seeing none, the motion is the passage of Senate Bill 122. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 122 is passed. Co-sponsors, Senators Kirkmeyer, Pelton B., Amabile, Rich, Mullica, Liston, Carson, Catlin, Exum. Please add the president. Mr. Schaffler, please read the title of House Bill 1039.
House Bill 1039 by Representatives Carter and Ricks and Senators Judah and Weissman concerning requirements for municipal jails.
Senator Weissman.
Thanks, Mr. President. We move for the adoption of House Bill 1039 on third reading and final passage and ask for a yes vote.
Further discussion? Seeing none, the motion is the passage of House Bill 1039. Are there any no votes? What? Senators Kirkmeyer, Frizzell, Zamora Wilson, Rich, Baisley, Pelton B., Liston, Bright, Pelton R., Catlin, Carson. With a vote of 23 ayes, 11 noes, 0 absent, 1 excused, House Bill 1039 is passed. Co-sponsors, Senators Marchman, Gonzalez, Wallace, Cutter, Kipp, Amabile, Benavidez, Henriksen, Exum. Please add the president. Mr. Schaffler, please read the title of Senate Bill 83.
Senate Bill 83 by Senators Weissman and Frizzell and Representatives Soper and Camacho concerning implementation of the Committee on Legal Services recommendations in connection with the legislative review of state agencies' rules.
Senator Frizzell.
Thank you, Mr. President. I move Senate Bill 26083 on third reading and final passage.
Further discussion? Seeing none, the motion is the passage of Senate Bill 83. Are there any no votes? Senators Zamora Wilson, Baisley, with a vote of 32 ayes, 2 noes, 0 absent, 1 excused, Senate Bill 83 is passed. Co-sponsors, Senators Colker, Carson. Please add the president. Mr. Schaffler, please read the title of House Bill 1098.
House Bill 1098 by Representative Brooks and Stewart R. and Senators Frizzell and Kipp concerning modifications to the Colorado Public Trustee Act related to foreclosure procedures.
Senator Frizzell.
Thank you, Mr. President. I move House Bill 261098 on third reading and final passage.
Further discussion? Seeing none, the motion is the passage of House Bill 1098.
Thank you.
Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, House Bill 1098 is passed. Co-sponsors. Senator Lindstedt. Please add the president. Now, Mr. Majority Leader.
Thank you, Mr. President. Pursuant to Senate Rule 21C, I move the Senate grant leave to the Joint Budget Committee to meet while the Senate is in session.
You've heard the motion. All those in favor say aye. Opposed, no. I need hearing aids because I feel like the ayes have it, and that motion is adopted. Y'all can get up out of here. General orders. Second reading of the bill's consent calendar. Senator Gonzalez.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of general order, second reading of bills, consent calendar.
You've heard the motion. All those in favor say aye. Opposed, no. No. Motion is adopted. The Senate will resolve itself in Committee of the Whole for consideration of general orders. Second reading of bills, consent calendar. Senator Gonzalez will take the chair. Get up in here.
Committee will come to order. The court rule is relaxed for everyone in the chamber. Mr. Majority Leader. No, Mr. Schaffler. Will you please read all the titles to all the bills on the general order, second reading of bills, consent calendar?
House Bill 1070 by Representative Hartsick and Brown and Senators Joseph and Frizzell, Judah and Frizzell, concerning third-party network lease agreements for dental services. House Bill 1034 by Representatives Johnson and Lukens and Senators Peltnar and Hendrickson concerning modifications to environmental standards for certain irrigation equipment. House Bill 1205 by Representatives Velasco and Morrow and Senators Cutter and Baisley concerning changes to state law to reflect the federal expansion of good neighbor authority agreements.
Thank you. Majority Leader Rodriguez.
Thank you, Madam Chair. I move for the passage of all the bills on general order, second reading of bills, consent calendar, which are House Bill 1070, House Bill 1034 in the Ag and Natural Resources Report, and House Bill 1205.
Is there any discussion on any of the committee reports? Seeing none, the motion before the body is the adoption on the committee reports. All those in favor say aye. Opposed, no. The aye has it. We will adopt those reports. Is there any discussion on any of the bills? Seeing none, the motion before the body is the adoption of all the bills on the general order, second reading of bills, consent calendar. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. Those bills are adopted. Majority Leader Rodriguez.
Thank you, Madam Chair. I move the committee rise and report.
Motion is to rise and report. All those in favor say aye. Opposed, no. Ayes have it, and we will rise and report.
The Senate will come to order. Senator Gonzalez.
Thank you, Mr. President. The committee met and considered some bills. Mr. Schaffler, will you please read the report?
March 24, 2026, Mr. President, your Committee of the Whole begs leave to report as had under consideration the following attached bills being the second reading thereof, makes following recommendations thereon. House Bill 1070, House Bill 1034 as amended, House Bill 1205 passed on second reading and ordered revised and placed in the calendar for third reading and final passage.
Senator.
Thank you, Mr. President. I move the report.
The motion is the adoption of the Committee of the Whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the Committee of the Whole report is adopted. House Bill 1070, 1034, as amended in 1205, passed second reading, order revised, placed on counter for third reading and final passage. General orders, second reading of the bill. Senator Gonzalez.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for general orders, second reading of bills.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. The Senate resolve itself Committee of the Whole consideration general order, second reading of bills. And Senator Gonzalez will take the chair.
Thank you. Committee will come to order, and the court rule is relaxed for everyone in the chamber. Majority Leader Rodriguez.
Thank you, Madam Chair. I move the Senate proceed out of order to take up Senate Bill 128.
The motion is to proceed out of order to take up Senate Bill 128. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. We will proceed out of order. Mr. Schaffler, will you please read the title to Senate Bill 128?
Senate Bill 128 by Senator Snyder and Kirkmeyer and Representative Lukens concerning a sales and use taxation exemption on certain fees charged by destination management companies.
Senator Kirkmeyer.
Thank you, Madam Chair. I move Senate Bill 128 and the Finance Committee report.
To the Finance Committee report. Senator Snyder.
Go ahead.
Thank you, Madam Chair. Yeah, in Finance Committee, we took out 2 lines that talked about goods and services. That was at the request of the Department of Revenue, and we thought we had solved their issue. But that certainly was something we wanted to make sure we got right, so we removed the lines out that deal with providing goods to support the activities described. And with that, I would ask for an aye vote on the committee report.
Is there any further discussion on the committee report? Seeing none, the motion before the body is the adoption of the Finance Committee report. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and that committee report is adopted. To the bill. Senator Snyder.
Thank you again, Madam Chair. So, folks, this is a question of really classification and somewhat of taxation. But we got a 7-0 vote out of the Finance Committee. There's no registered opposition. We have a 0 fiscal note, which I want you to know that we have been working with Department of Revenue to try and come up with a path forward. And I appreciate the efforts of the good senator from Fort Collins in weighing in. We started to get some movement just here in the last couple of days. But in the end, if you just look to the fiscal note, it says, defining DMCs as service providers, the bill does not alter the number of times sales tax is required to be paid. Rather, it clarifies that by whom sales tax is required to be paid. By DMCs when they purchase taxable goods or services on behalf of their client, and not by the client purchasing DMC services. As a result, the bill will reduce sales and use tax to the extent that a DMC was erroneously paying sales tax on both their purchases and their sales. So these companies already pay all applicable sales and use tax. They do not have a wholesaler license. They're not buying at a discount and marking it up. The goods that they get in furtherance of their business and their clients all pay all applicable sales tax. This is a question of how should their service fee and labor be taxed, which we don't do here in Colorado. All this does is clarify that what they're doing now is the right way to go.
Cool, cool, cool. You love to see it. Further discussion. Senator Kipp.
Thank you, members. And I will say that I was a yes vote in Finance Committee because at the time, I believed that this bill was just based on a misunderstanding of how the billing was done and that there needed to be some clarifications around how these companies reported. But we've continued those conversations, and frankly, people have told me, yeah, I had this 2-hour meeting and I'm still really confused. I think where I land on this is I am very concerned about passing this bill. And I will be a no vote. And I want to explain to you why, and it's not very simple. So if you want to pay attention, that would be great. If not, I totally get it. So had several discussions with the Department of Revenue. And let me give you an example. If you were to go to a retail store and buy a chair, for instance, there is a component of labor that somebody had to assemble that chair, and you are getting taxed on the whole thing. We do not tax in Colorado for services alone, and that is the differentiation. So what the issue is here is what we would be doing is actually carving a particular industry, a particular type of business out of statute and saying you do not have to comply with our sales and use tax laws the way all of these other industries do. And I just have to tell you that's really problematic in setting that precedence. And I know this might be a little longer than I usually talk, but I just think that this was a very cogent explanation that I received from the Department of Revenue, so I'm just going to share it with you. It says part of the confusion may come from the fact that the terms used in the sales tax article have a technical meaning that may differ from the more common understanding of the term. For example, a retailer is generally any person who sells at retail. That is, any person selling to a final customer and not for resale. A business that may be regulated as a service is a retailer when selling goods. For example, a hair salon is a retailer when they sell shampoo, even though they are generally in the service industry. Even though they are a retailer when selling goods, their services remain non-taxable. A wholesale purchase is generally any purchase for resale. A wholesale purchase is not limited to purchases from a particular type of seller, purchases of large quantity, or purchases for a discounted price. For example, some food and grocery delivery services operate by purchasing restaurant meals and groceries and then reselling them to their customers. These are wholesale purchases, and those businesses must collect sales tax on the price they charge their customers for those items. Conversely, when a business that is commonly known as a wholesaler sells to a customer, that sale is a retail sale. Finally, the taxable purchase price of a good includes the entire amount paid or promised to be paid by the purchaser to acquire the good. Although Colorado taxes a limited list of services, the purchase price of goods always includes elements that could be characterized as services. The price of manufactured items includes the cost of the labor to manufacture them. That is key. Goods sold at retail stores had to be sourced by the retailer, transported to the store, stocked, and sold by a sales representative. Together with other elements such as overhead and profit, these elements of the price are subject to sales tax. This is similar to the conclusion reached in City and County of Denver versus Expedia in 2017. In that case, the Colorado Supreme Court concluded that the taxable price for the city's lodging tax included charges that the online travel companies characterize as compensation for providing travel-related information and online facilitation services. Just like the hair salon selling shampoo, destination management companies are retailers when they sell gift bags, food, and hotel rooms to their clients. The price they charge their clients might include some cost to source the gifts and assemble the gift bags. Nonetheless, these elements of the purchase price charged to the client are subject to tax. Conversely, separately stated charges for organizing and staffing meetings, providing shuttle services, and booking entertainers are not subject to tax, much like the haircut provided by the salon. So I know that was kind of a long explanation, but I wanted to be really clear that what we are doing here is carving out an industry if we allow this bill to move through so that they don't have to treat taxes, sales and use taxes, like everybody else does. If we think we need to reform sales and use tax laws in Colorado, that is one thing, but carving out a specific industry is actually a problem, and so that's a poor precedent. The fiscal note on this bill is zero, and I asked them about that, and they said, we don't really expect this to make a big difference in the amount collected. What we think is going to happen is that it is creating a problem with how the taxes are collected and setting a bad precedent that could be used by other parts of the industry. That is why I'm sorry to say that I am rising in opposition to this bill today. Thank you.
Thank you. Further discussion. Senator Benavides. Senadora Benavides.
Gracias. Thank you, Madam President. Members, I'm also standing.
I'm a chair. I'm just a
What?
chair. But go on ahead.
Madam Chair. Uh-oh.
Yeah, we're in the Senate, homie. It's all
Apologize,
good.
I gave you a promotion.
No.
No honors.
Please.
All right. Let me get back to the bill. Okay. I'm also standing in opposition to this bill, and I do agree with my colleague. And the reason I'm against this bill, it's difficult to understand. It's a fancy name of destination managers for event planners. You all have been to a conference or a meeting or a convention, and they hire a company in the location to do all the stuff for you. And all of that stuff includes little trinkets you may get. You know, you always get a nice bag to carry your stuff around in. All of those things are all goods, and they're all subject to sales tax. They also provide services. The people that are helping them, those are services. So your entity gets billed for all of that. And apparently there has been some confusion in a few places in Colorado where the event planners, the destination management companies, were being charged sales tax on the entire amount, which includes services. And right now, we don't charge sales tax on services. So I think there is a problem, and I think the sponsors identified a problem. But the way to fix it is not to say, okay, you event planners, you don't have to pay sales tax on anything. That is not the answer. And this gives them an exemption to sales tax. And that's a real problem because, as my colleague pointed out, this is an industry that is a for-profit industry. And they would be exempt from sales tax for the goods they purchase and for the services they provide. That is not something, the best answer to this. And if this were to pass, this will be the only for-profit industry that's exempt from sales tax. Most of you are aware that nonprofits can be exempt from sales tax. And there is a process with Department of Revenue where they have to go in and show they have 501c3 status, they have to show they're in good standing, and they have to do that on a regular basis. And they receive a certification. So when they go to retailers, they're not charged sales tax. There is no process in this bill to identify destination management companies, and it says that they have to provide these services at least 6 times. So there's no way to tell for retailers. They're not going to get any cute little certificate that nonprofits get to say, I'm exempt, don't charge me sales tax. This bill contains no procedure, no process. It's a zero fiscal note. There is no rulemaking on how to do that. So it's going to cause a lot of confusion were it to pass. But for me, the biggest problem, it creates a huge slippery slope to give a for-profit business a exemption to taxes where no one else gets it. Other for-profit businesses in different industries could come forward and say, hey, you give it to these guys, we do important work, why aren't we getting that exemption? So I think it's a problem, but I don't believe this is the way to fix it. So I ask that you not pass this bill.
Thank you, Senator Benavides. Further discussion, Senator Snyder.
Thank you, Madam Chair. Just a quick correction. These companies pay all sales and use tax. It's estimated they pay $1.2 million in sales and use tax every year. When they purchase goods for their clients, and that could be a caterer, or that could be a goodie, a swag bag, or whatever it might be, all those taxes are paid. And what DOR is saying that they should be taxed when they bill their clients who they're performing the services for. That is just fundamentally different than the way we do things here in Colorado. They are not a nonprofit. They do not have a wholesale license. They pay the full retail amount. A local government, in this case Denver, did an audit of one of these companies to see what was going on, and thinking that they should have their service fee be subject to sales and use tax. The effort was ultimately unsuccessful because they could not justify imposing a sales and use tax on a legitimate services DMCs provide.
Senator Kirkmeyer.
Thank you, Madam Chair.
So members, just the short of it is this. This bill is to clarify that these are service providers. You heard about the local government that already went through and did an audit to justify that they can't impose the sales tax. Our state law is already very clear. There's substantial statutory evidence that services are not subject to sales and use tax. This is not a hair salon. They don't go get a retail tax license to sell shampoo or sell anything. This is not a carve-out. They are not currently being charged sales tax because they are a service provider. This is not an exemption. They're not being exempted from paying sales tax. They don't pay sales tax now. We are just making sure that everybody understands they are a service provider, they're not a wholesaler, that they don't need to have sales tax. That's what this bill is about. It's just a clarification. Ask for an aye vote.
Further discussion? Seeing none, the motion before the body is the adoption of Senate Bill 128. All those in favor say aye.
Aye.
Opposed, no? No. The ayes have it. 128 is adopted. Mr. Majority Leader.
Thank you, Madam Chair. I move the committee proceed out of order to take up Senate Bill 113.
You've heard the motion. All those in favor say aye. Opposed, no. The aye has it, and we will proceed out of order to take up Senate Bill 113. Mr. Schaffler, will you please read the title to Senate Bill 113?
Senate Bill 113 by Senators Amabile and Ball and Representatives Carter and McCormick concerning requiring a recovery residence to obtain a license from the Behavioral Health Administration.
Senator Amabile.
Thank you, Madam Chair. I move Senate Bill 113, the committee report and the Appropriations Committee report.
To the HHS report, Senator Amabile.
In the Health and Human Services Committee, we ran a few amendments at the request of stakeholders to clarify how these properties can be used and who can run them. In the Appropriations Committee, we...
Well, one report at a time.
Okay, sorry.
Is there further discussion on the HHS report? Seeing none, the motion before the body is the adoption of the HHS report. All those in favor say aye.
Aye.
Opposed, no. Ayes have it. HHS report is adopted. To the Approps report, Senator Amabile.
Thank you, Madam Chair. In the Appropriations Committee, we ran an amendment to get the appropriations down to 0.
Further discussion? Seeing none, the motion before the body is the adoption of the Appropriations Committee report. All those in favor say aye. Opposed, no. Ayes have it, and that Approps report is adopted as well. To the bill, Senator Amabile.
Thank you, Madam Chair. I would like to move Amendment L007.
There is an amendment at the desk. Mr. Schaffler, will you please read L7?
Amendment L007, amend printed bill
Senator
page 3.
Amabile.
Okay. I move Amendment L007 to Senate Bill 113.
That is a proper motion to the amendment.
So this amendment just makes it clear what type of facility these are, and it also clarifies that people who come to this facility who are using MAT treatment can continue to receive that treatment and can't be forced to not receive it or to have it taper down.
Thank you.
I ask for a yes vote.
Thank you. Further discussion on L007? Seeing none, the motion before the body is the adoption of L7 to 113. All those in favor say aye.
Aye.
Opposed, no. Ayes have it, and L7 is adopted. Senator Amabile.
Thank you, Madam Chair. So the bill is pretty simple. We have what we call recovery residences here in Colorado. We had a third party that was certifying these residences. We found that there were some bad actors in the space and that people who were going to these residences weren't necessarily getting the kind of treatment and care that they thought they were getting. And we had people in neighborhoods in various cities who were saying, hey, I don't think that this home is doing what they told us it was going to do. And so we're going to bring that licensing under the BHA, and that will give us more flexibility in making sure that these recovery homes are doing what they say they're doing, and we will have some oversight over them and some ability to shut them down if they're not doing the right thing.
Senator Ball.
Thank you, Madam Chair. I'd like to thank my co-sponsor and encourage an aye vote. I think one thing this bill goes to show is we do need to be careful about what government functions we outsource. And I think what's happened with the recovery residences is proof of that. When you outsource things like compliance and inspections, it's really hard to hold accountable the people that those third parties are intended to inspect. So I think the hope with this bill is that by bringing that in-house, we are able to ensure that recovery residences are held to a high standard, and in turn, that will help people get the help that they need.
Further discussion on 113. Seeing none, the motion before the body is the adoption of Senate Bill 113. All those in favor say aye. Opposed, no. Ayes have it, and 113 is adopted. Mr. Majority Leader.
Thank you, Madam Chair. I move the Senate proceed out of order to take up Senate Bill 121.
Motion is to proceed out of order to take up Senate Bill 121. All those in favor say aye.
Aye.
Opposed, no. Ayes have it, and we will proceed out of order. Mr. Schaffler, will you please read the title to Senate Bill 121?
Senate Bill 121 by Senators Rodriguez and Simpson and Representatives Martinez and Winter T, concerning the establishment of a threshold for when an agricultural employer is required to pay overtime to an agricultural employee.
Senator Simpson.
Thank you, Madam Chair. I move Senate Bill 26-121 and the Business, Labor, and Technology Committee report.
To the PLT report, Majority Leader Rodriguez.
Thank you, Madam Chair. In the committee, we amended the bill to extend the implementation date till 2027 and also put some of the rulemaking into statute so there would not have to remove the fiscal note. Ask for an aye vote.
Is there further discussion on the BLT report? Seeing none, the motion before the body is the adoption of the BLT committee report to 121. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and that BLT report is adopted. To the bill. Senator Simpson.
Thank you, Madam Chair. Pleased to be bringing forward this policy conversation with the Majority Leader about agriculture and the industry and the workers and the community. I highlighted in committee, this truly is not about competing interests of producers and a workforce. There's real value and necessity in recognizing that we need each other. We need workers who are valued, respected, along with a healthy, profitable ag economy to drive to better outcomes for this industry that's really struggling at this point in time. Many times, ag labor in particular sometimes gets wrapped up as kind of like industrialized and in manufacturing centers, and you lose some of the reference producers that I know that pay well above minimum wage, that provide housing, that provide transportation, that provide bonuses, that provide cell phones way above and beyond just a simple hourly rate. So I think this proposal, this bill, really does get to a spot that creates a system that both of us can, I would like to say we thrive, at the very least we kind of survive where we're at right now. Such a challenging industry and margins are so tight, and I don't know why I torture myself every day. I look at snow forecasts and what water supplies are going to look like, and I can tell you this morning in the southern half of the state, we're now below 30% of average for snowpack, and so I'm trying to figure out how's my farm going to survive this season with that kind of snowpack. So this is just an effort, again, to help, and from my perspective, again, help the workforce and the producers be a viable machine in the state of Colorado, and ask for your support on Senate Bill 121.
Thank you. Further discussion? Senator Rodriguez.
Nope.
There's an amendment at the desk. Mr. Schaffler, will you please read L6 to 121?
Amendment L6, amend the Business,
Senator
Labor.
Rodriguez.
Thank you, Madam Chair. I move L006.
To the amendment.
Thank you, Madam Chair. This is a technical amendment clarifying some corrections on the committee report. It's just technical in scope. It does not make any substantial changes to the policy.
Further discussion? Seeing none, the motion before the body is the adoption of L6 to 121. All those in favor say aye.
Aye.
Opposed, no. The ayes have it. L6 is adopted. Mr. Schaffler, there's another amendment at the desk. Will you please read L24 to 121?
Amendment L24.
Senator Rodriguez.
Thank you, Madam Chair. I move L024.
To the amendment.
Thank you, Madam Chair. This amendment reduces the threshold from 60 hours to 56 hours, which is the cap under the current rulemaking law. So we lowered it from 60 to 56. It also amends the title to insert the 56 hours of the work week.
Is there further discussion on this amendment? Seeing none, the motion before the body is the adoption of L24 to 121. All those in favor say aye. Aye. Opposed, no. The ayes have it. L24 is adopted. To the bill. Senator Wallace. There's an amendment at the desk. Mr. Schaffler, will you please read L7?
Amendment L7.
Senator Wallace.
Thank you, Madam Chair. I move Amendment L007 to Senate Bill 121.
To the amendment.
Thank you, Madam Chair. This amendment will change, while I understand that we just dropped by a few hours the bill's mandate to move overtime from 40 hours to 60 hours. This amendment would set the overtime threshold at 40 hours a week and 12 hours a day. When Congress enacted the Fair Labor Standards Act of 1938, agricultural and domestic workers were excluded from our basic workplace protections, such as minimum wage and overtime, like we are discussing today. These exclusions were not accidental. The Southern Democrats required the exemption in order to gain their support for the legislation because they did not want to provide protections for Black and brown workers who overwhelmingly made up these workforces. Since then, nearly 90 years later, agricultural workers continue to be excluded from basic labor protections. For too long, farm workers were excluded from labor protections rooted in racist and unjustifiable policy choices. Moving to overtime after 40 hours is an important step toward ending that unequal treatment and ensuring farm workers are treated with the same dignity and fairness they deserve. This was the step that we took in 2021. These were the wrongs that we were trying to rectify. A 40-hour threshold reflects the standard overtime rule that applies to most workers. Farm workers should not be singled out with weaker protections simply because their labor has historically been undervalued. I want to read from our original ledge deck in 2021. The director shall consider the inequity and racist origins of the exclusion of agricultural employees from overtime and maximum hours protection available to other employees. These workers shouldn't be singled out. That's what this legislation is about, and I think we should aim to correct it with this amendment. Thank you, Madam Chair.
Further discussion on L7. Senator Simpson.
Thank you, Madam Chair. I rise in opposition to L007. We actually heard in the Business, Labor, and Technology Committee at the same time this bill was running an alternative proposal to do this, what this amendment's proposing to do. It did not pass out of committee. And I just continue to highlight, like, we're trying to find a space to keep the industry really viable and workforce. Like, if you're going to lower this to 40 hours, with such tight margins in the industry, you're going to find, and this is real world what's happening, producers will stop growing things that are labor intensive. They are already doing that. Farms that went from employing 100 employees seasonally to now employing 5 because they could not make the economics work out trying to pay overtime in this space in such tight margins. You're going to drive producers to mechanization faster than maybe it would happen originally, and or just get out of business. Colorado's lost 1.6 million acres in productive agriculture from 2017 to 2022. Part of that drive in loss of, there were many things that drove that, and one of them is the economics, climate, input costs, lots of things drove that. But reducing the threshold to 40 hours will just put more pressure on the system, and I think ultimately you'll actually see a smaller workforce and end up hurting the people you intend to try to help. I ask for a no vote on L007.
Senator Rodriguez.
Thank you, Madam Chair. I can't say it better than my colleague. I ask for no vote.
Senator Liston.
Thank you, Madam Chairman. Well, I serve on the Business, Labor, and Technology Committee members, and we heard extensive testimony regarding this amendment. In fact, we heard from the former Commissioner of Agriculture for the state of Colorado, former Congressman Salazar, who was very much in favor of this of Senate Bill 121, and I know that he was against. He would be against Amendment L007. We also heard from numerous workers who and others that if this amendment were to be implemented, it would actually curtail their pay. They come to the various farms, whether they're indigenous to this country or not. They want to work, they're capable of working, they want to work the hours, and that they also keenly realize that if it was, if overtime were starting to be implemented at 40 hours, that they would suffer. So the very people that this amendment is supposedly meant to help would actually penalize them. So members, after hearing numerous witnesses here just this past week, I would urge a no vote on Amendment L007.
Further discussion on L7? Seeing none, the motion before the body is the adoption of L7 to 121. All those in favor say aye. Aye. Opposed, no? No. The noes have it, and L7 is lost. To the bill. Senator Cutter. So before I recognize you, I love, one of my favorite things about the upper chamber as opposed to over there, whatever that is, the dark place, is that we actually debate here. And so as I welcome folks debating, I just want folks, if you make eye contact with me, if you want to get in the queue, I welcome folks being in the well. I appreciate that as opposed to trying to raise your hands from your seats. So with that, thank you. And Senator Cutter.
Thank you, Madam Chair, and thank you to the sponsors. I know you've been working hard, but obviously we think there are still a few things that we can improve. So I would like to move Amendment L13.
There is an amendment at the desk. Mr. Schaffler, will you please read L13 to 121?
Amendment L13. Amend the Business, Labor, and Technology Committee report dated March 19, 2026, page 1, strike lines 1 through 12.
Senator Cutter.
I move Amendment L13.
To the amendment.
So this amendment adds a legislative declaration that mirrors the LegDec language in Senate Bill 81, which was the bill that my good colleague from Lakewood ran to give ag workers overtime pay after 40 hours of work. So the LegDec calls out the discriminatory origins of the exclusion of ag workers from basic overtime protections. This exclusion dates back to Congress' decision to exclude ag and domestic workers from the Fair Labor Standards Act of 1938. The Southern Democrats required this exemption in order to gain their support for the legislation because they did not want to provide protections for black and brown workers who overwhelmingly made up those workforces. See, we can all evolve. The LegDec also calls out the importance of extending equitable overtime pay to ag employees to signify the value of their labor, and I would urge an aye vote.
Further discussion on L13. Senator Rodriguez.
Thank you, Madam Chair. Colleagues, I ask for a no vote on this amendment. While I appreciate this was all the discussion that we had in the committee. While I don't disagree that the bill we ran in 2021 that did address a lot of these protections are in it. Prior to this, we didn't have any thresholds for overtime, and we have compromised to go to the 56 hours. We ask for a no vote.
Further discussion on L13. Senator Wallace.
Thank you, Madam Chair. I just want to say that while we appreciate that the sponsors have moved from 60 hours to 56, that is still 16 hours more than every other worker qualifying for overtime.
Further discussion. Senator Rodriguez.
Thank you, Madam Chair. Thank you, colleagues, for the conversation. Yes, it's a lot more, it's a threshold that even we don't have.
Further discussion on L13. Seeing none, the motion before the body is the adoption of L13 to 121. All those in favor say aye. Opposed, no? No. The noes have it, and L13 is lost. To the bill. Seeing no, Senator Cutter. There's an amendment at the desk. Mr. Schaffler, will you please read L9?
Amendment L9.
Senator Cutter.
Thank you, Madam Chair. I move Amendment L009.
To the amendment.
This simply changes the rate of 1.5 times normal pay to 2 times the rate of normal pay in their overtime amount. And I would urge an aye vote.
Further discussion on L9. Senator Simpson.
Thank you, Madam Chair. I rise in opposition to L9 for a lot of the same reasons. We are just making it exponentially harder to make this business work, and eventually you will hurt the workers we intended to try to help. Ask for a no vote on L9.
Senator Liston.
Thank you, Madam Chairman. Well, I rise in opposition to L9. You know, one of the themes that we've heard consistently, members, is affordability. And so if we raise it from the normal to 2 times the normal rate, well, that's going to do nothing but drive up costs, and we're all going to end up paying more. So in this atmosphere that we have about keeping prices lower and affordability, this would run counter to everything that we've been talking about. I would urge a no vote on Amendment L9. Thank you.
Further discussion. Senator Marchman.
Thank you, Madam Chair. I rise in support of L009. If we're going to make ag workers work 16 hours more than other workers in the state before they can receive overtime pay, then they should get even more than the standard overpay. Thank you for considering this amendment.
Further discussion. Senator Catlin.
Thank you, Madam Chair. I'm here to speak against this amendment for a couple of different reasons. First off, we're talking about trying to make things a little more affordable, which I don't want anybody to assume we're putting that on labor's back. But the point I'm trying to make is that if we go to 40 hours, or if we stay at 56, and we're going to go to double time, what'll end up happening is the farms that will try to hire more employees to have 2 crews rather than 1. And once that happens, they're not going to be able to find the labor, for one thing. Secondly, they won't be able to maintain it. And people will be given jobs on a spot basis. They won't be helping the employees. They won't be helping the people that are there trying to harvest the crop and or plant it. I think one of the things that everybody should take a deep breath and think about is labor is critical to our ag production. Without it, we won't have ag. We will have things that you can harvest with a machine. A man and his son or a man and his family will be the only people working on that farm. Right now, ag is supplying really a lot of jobs in the state of Colorado. When we start talking about agriculture, we always talk about the 195,000 or however many jobs agriculture's got, partly because there's not enough labor to create 2 crews or 3 crews, 24-hour operations, because the labor's not there. Folks, this is one of the things that we can do for agriculture right here, right now, is to go about what this bill is trying to do, and this amendment goes directly against it. I'd ask for a no vote.
Is there further discussion on L9? Seeing none, the motion before the body is the adoption of L9 to 121. All those in favor say aye. Aye. Opposed, no. No. Noes have it. L9 is lost. To the bill. Senator Wallace.
Thank you, Madam Chair. This bill currently includes some exemptions for managers and sheep herders, and I have an amendment to that end, ma'am.
Mr. Schaffler, will you please read L12 to 121?
Amendment L12.
Senator Wallace.
Thank you, Madam Chair. First off, to this bill's exemption for managers. As written, the exemption for overtime for, quote, decision-making managers provides a significant loophole that essentially renders the provision of overtime to farm workers meaningless. By applying generic, often misleading managerial titles to salaried positions, employers can essentially deny overtime to employees who spend the majority of their time performing non-managerial tasks. Wage theft studies have found that misclassification of workers by falsely classifying them as managers is a prevalent tactic used to avoid paying overtime to employees who perform standard hourly duties. And therefore, in part, this amendment would strike that exemption. It would also remove the exemption for range workers. Sheep herders, goat herders, and cattle herders are required to work extremely long hours caring for the livestock out on the open range and keeping them safe from predators. They often live in isolation without electricity or running water. According to a 2010 study, Colorado sheep herders often work between 80 to 90 hours a week and do not get a day off. Most workers on call 24/7 are entitled to be paid for all hours their freedom is restricted. Sheep herders, however, are not. They don't even make Colorado minimum wage for the hours they do work, which is estimated to be, again, 80 to 90 hours per week. For this reason, sheep herders and other range workers should be paid overtime when working more than 60 hours per week, just like the other agricultural workers, or I suppose now 56 hours a week. Given today's technology, it's not reasonable for the ranching industry to claim that they cannot track the hours of sheep herders and range workers who are out on the range with our livestock, often 24/7 and without a day off.
Further discussion, Senator Simpson.
Thank you, Madam Chair. I rise in opposition to L12 and would think about, I'm not sure we found evidence of wage theft in this space in ag communities since the introduction of overtime after the bill in 21. It's just like a false premise that just doesn't exist. And here's part of the challenge in this bill when we tried to lump all of agriculture together as one industry and not a recognition of what sheep herders do at 10,000 foot of elevation where they live there remotely for the entire summer sometimes versus a dairy or a feedlot or my farm or a range rider. There are such distinct differences in these labor forces that trying to lump them all together into one space is problematic. I can't emphasize enough about the necessity of trying to treat these different workforce pieces differently, because we shouldn't try to lump them all together under one category.
Further discussion, Senator Rodriguez.
Thank you, Madam Chair. Thank you, colleagues. That's the core of the discussion we're having on this bill. This isn't an industry where it's a warehouse and they can work 8 to 5 and they can put things in a refrigerator. These are lives. These are animals. You know, when you go home from your 8-hour job, the work's still there, the animals are still there, this work still needs to be done. And the hard part we deal with this is and in 2-3 weeks, we're gonna be dealing with a budget of cuts that we're only allotted so much money. This industry can't raise prices to do the work. Therefore, they have to work within the means. We tried to make meaningful concessions in this bill. I ask for no vote.
Is there further discussion? Senator Wallace.
Thank you, Madam Chair. I will just say I agree that this is work that goes around the clock and that demands people be there. And all we're asking with this amendment is that those folks be considered for the same overtime as other agricultural workers, given the demand of the work that they are doing.
Senator Simpson.
Thank you, Madam Chair. So if we do this, there will be no more sheep in Colorado. You can't afford to pay a sheep herder remotely by themselves in their own trailer for 24 hours of work, because they're basically with the herd the whole time. And they're largely just watching and moving animals to graze in the right spot. If you include that in this calculation, there will be no sheep in Colorado anymore. I ask for a no vote.
Senator Catlin.
Thank you, Madam Chair. I'm here. I wanted to talk a little bit about what it's like herding sheep. What you do when you're herding sheep up in the mountains is that you tend them. In other words, you are there, perhaps sitting under the tree watching them, but the work effort is not what you and I are talking about here. It's not like factory work. It's not like pouring concrete. It's not like those kind of intense labor jobs. The people that come here from Peru, for example, in my community, they live at like 10,000 feet year-round. But they love the mountain. They love being there with the sheep. They love being in that lifestyle. In fact, the ranchers provide them a camp. You and I would call it a trailer. But it is built in a way that every need they have is there. Their food, their heat, their everything is in that camp. They like the idea that they are that far away from the rest of the world because they tend the sheep. They don't necessarily work the sheep. They're there to protect against predators. They're there to protect against other human predators. They're there to just take care of that herd. And they believe that herd is like theirs. Most of these people come back and forth between the U.S. to herd sheep for 20 years or more. And if you bring one of those workers down off of the mountain and you put them onto a farm, they will quit and go home because that's not what they do. They love the animals. They take care of those animals. You know, the language they speak to their dogs. We can't talk to the dogs after the man goes home because he's speaking to that dog every day in his native tongue. When he comes home and leaves the dog here, well, what do we do with him? We have to find somebody that can talk to the dog. Because it's a lifestyle. It's not necessarily an employment contract. It's these guys taking care of those sheep so that those sheep, when they come off the mountain, they've done the best they can do with pounds. And in agriculture, folks, the only thing that keeps us going is how many pounds do we sell. It doesn't matter if it's potatoes. It doesn't matter if it's sheep. It's how many pounds do you sell. And these people are experts, and they agree to the salaries and to the payment. They agree. They're not forced. They volunteer to come here because they love it, they want it, they love the men and women that own those sheep. They are part of the team. I'd ask for a no vote.
Love me a bilingual dog. Further discussion? Seeing none, the motion before the body is the adoption of L 12 to 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L 12 is lost. Senator Marchman.
Thank you, Madam Chair, and thank you to the bill sponsors for bringing this bill. I know you have worked hard to try to come up with some compromise. I am concerned about this bill. When I go to meet and greets, people ask me, I sure hope you're going to oppose the bill where they're raising the ag workers' responsibilities. And so that's why I am here. I do have an amendment that I would like to offer. It's going to be pretty similar to what you've seen.
Thank you. Mr. Schaffler, will you please read L 10 to 121?
Amendment L 10.
Senator Marchman.
Thank you, Madam Chair. I move L 10.
To the amendment.
Great. So in L 12, we saw the exclusion of decision makers and sheep herders. This amendment is just excluding the sheep herders from the overtime exemption. So it's the same reasoning for why. It's just another look at it. If we could just exempt the exclusion of the sheep herders from the overtime exemption. I ask for an aye vote on L 10.
Further discussion on L 10. Senator Simpson.
Thank you, Madam Chair. Again, I'll rise in opposition to L 10 for largely the same reasons and conversation we had before. If you want to see the industry leave Colorado, exclude sheep herders from this conversation. And I would highlight the good senator from Montrose's discussion and about how there's such a differentiation between industrialized warehouse type workers and sheep herders in particular. They truly are like family. You can talk to people that, and there aren't very many people in Colorado anymore that run sheep. It's pretty minimal to begin with. Their connection and relationship to the sheep herders largely routinely from Peru. And They truly are very much like family, and a recognition of trying to make sure that those folks in very remote locations are well taken care of and are happy and content in what they're doing. And again, for largely the same conversation we had with the last amendment, I rise in opposition to L10.
Further discussion, Senator Liston.
Thank you, Madam Chair. Well, members, once again, the sheep herders, that is a way of life for these good people that can do this. There's not very many of us here in Colorado that can do the job the way that they are trained. It's a lifestyle. They've grown up herding sheep since they're this high. These are highly trained people, be it from Peru or the Basque region of Spain. They know what they're doing. They like what they're doing. And if we raise their wages, there will be no sheep herders that we need. So with all due respect, I would urge a no vote on Amendment L010.
Senator Wallace.
Thank you, Madam Chair. Once again, I agree that these are valuable skills that take a lot to learn how to do, that are, take a lot of not only our time to learn, but also our time to produce. That value deserves to be paid, and all we are asking for with this amendment is that those workers be included. The amount of times that we hear in this chamber that a whole industry will disappear from Colorado because of something that we're doing, including paying workers fair wages for working 7 days a week, mind-boggling. I would think we would have no industry left in Colorado after all of this, after every time that I've heard that. Pay our workers fair wages.
Senator Simpson.
Thank you, Madam Chair. I would highlight these particular sheep herders from Peru come back every year. There are people that have been doing this for decades, for 30 years. Their sense is they're getting a fair wage. The owners, the livestock industry has a good relationship with these folks. Like to characterize it as unfair, I think, is an overstatement. That's why they keep coming back year after year after year after year, because they like the work and they feel fairly compensated.
Senator Marchman, did you? Okay, Senator Peltonar.
Thank you, Madam Chair. I rise in opposition to this. Here again, we see a situation where there's activist groups, city people trying to tell agriculture how to do their business. These people know when they take these jobs just exactly what they're signing up for. Agriculture is different for a reason. It was set up different. We should have never had the original Ag Labor Bill in 21, and now this bill is trying to rectify some of the problems with that bill. This amendment would just muddy the water some more, so I rise in opposition to L10.
Is there further discussion? Senator Catlin.
Thank you, Madam Chair. I heard a couple of things that I'd like to address in regards to the sheep industry. Montrose, Colorado in the 70s shipped 250,000 lambs per year from that shipping point. 250,000. Today, there are less than 20,000 sheep in the whole area. The industry is shriveling and dying from a lot of different reasons. But this purpose here today, in regards to paying them 24 hours a day, will put the death knell on it. I'm not going to say that it will happen today or tomorrow, but sooner or later it will be done. And you and I need to realize how valuable sheep are in the mountains. Where they're grazing, they're not burning. It's in areas that are not grazed that are ended up burning. This is a symbiotic relationship, if you want a fancy word. Maybe I'm not using it right. But the sheep help the mountain keep the sheep. We need men, particularly, it's pretty much male-dominated, of people who know how to tend the sheep and move them from one pasture to the next. And the idea that they're up there alone all year is not true. The people that own those herds are up there checking on them weekly. They know where they are, they know what's going on, and they check on their men. They don't just go up and say hello. They'll spend a day helping, doing whatever it is that needs to be done that day. But these guys that own those outfits know that that man up on the mountain is important and is critical, not because of the labor, but because of the attention. Folks, we've got to understand that when people agree to do something with each other and for one another, and we negotiate the price, it's a negotiated contract. We don't need to step in between and say, no, 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 we know better. Folks, this is one we need a no vote, please.
Is there further discussion? Senator Wallace.
Thank you, Madam Chair. I was wondering if the proponents of this bill might speak to how much it costs to apply the guest worker visa annually.
Is there further discussion? Seeing no further discussion on L10, the motion before the body is the adoption of L10 to Senate Bill 121. All those in favor say aye. Aye. Opposed, no? No. The noes have it. L10 is lost. Now, prior to us proceeding forward, I just want to acknowledge, and so with respect, the last amendment that we brought forward, L12, Senator Wallace spoke to the amendment, but did not actually move the amendment. And so I'm going to, just for proper procedure, I'm going to invite Senator Wallace back up to move L12, and we will reconsider said motion. Thank you, Senator Wallace.
Thank you, Madam Chair. Apologies, members. I move L12. The amendment's so nice, we had to address it twice.
There you go. Thank you. Thank you for bringing that forward for our consideration. There are no settled questions in the Senate. Here we are. So with that, that L12 has been moved. Is there further discussion on L12? Seeing none, the motion before the body is the adoption of L12. All those in favor say aye. Opposed, no. No. The noes have it. L12 is lost. Okay, to the bill. Senator Marchman.
Thank you, Madam Chair. I appreciate the conversation that we've just had about sheep herders, and there's something about data that makes me
You guys,
really
somebody's phone is ringing.
engaged.
It's really awesome.
So it was fascinating to hear the senator from Montrose discuss the reduction in sheep herders that we have now. But I do want to take another poke at L12.
There's an amendment at the desk. Mr. Schaffler, will you please read L11?
Amendment L11.
Senator Marchman.
Thank you, Madam Chair. I move L11.
That has been properly moved to the amendment.
Great. Thank you, Madam Chair. So Amendment 11 does what 12 would have done, but that one was lost. And this focuses on the decision makers. And I just want to be really clear about what this is. There's an exemption from overtime for decision-making managers. And it really does provide a significant loophole that essentially renders the provision of overtime to farm workers meaningless. By applying generic, often misleading managerial titles to salaried positions, employers are able to essentially deny overtime to employees who spend the majority of their time performing non-managerial tasks. Wage theft studies have found that misclassification of workers by falsely classifying them as managers is a prevalent tactic used to avoid paying overtime to employees who perform standard hourly duties. The misclassification in particular of dairy workers as decision-making managers has been discovered at Colorado dairies in recent years as attempts to avoid paying overtime. This would protect so many of our dairy workers. I urge an aye vote on L011.
Further discussion, Senator Simpson.
Thank you, Madam Chair. Again, I rise in opposition to L011 and the concept of we've created some loophole for industry to avoid paying overtime. That just doesn't play out in the real world with cases of theft, wage theft in the ag industry. It's a loophole that doesn't really exist. I don't think we need this amendment, so I'm encouraging a no vote on L011.
Is there further discussion? Seeing none, the motion before the body is the adoption of L11-2, Senate Bill 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L11 is lost. Senator Marchman.
Thank you, Madam Chair, and I sure appreciate the Chamber's willingness to engage in this conversation today. We're going to keep trying to narrow this just a little bit because I think we truly are on to something. One second.
Mr. Schaffler, will you please read L14 to the Senate Bill 121?
Amendment L14.
Senator Marchman.
Thank you, Madam Chair. I move L14.
Proper motion to the amendment.
So Amendment 14 would narrow the exclusion of those decision-making managers from overtime exemption to supervisors at livestock employers. So currently, under our Colorado wage laws, executives or supervisors paid a salary and who supervise at least 2 full-time employees and have the authority to hire and fire are exempt from overtime. Similarly, there's the overtime exemption for decision-making managers of livestock employers who are paid a salary. This amendment makes these overtime standards more in line with other Colorado laws that govern overtime in other industries as applied to supervisors. The common practice of misclassifying workers as managers to avoid paying overtime is common, unlawful. So an amendment that provides guardrails to ensure that those who are excluded from overtime are in fact supervisors who have the power to fire and hire is necessary. The misclassification of dairy workers as decision-making managers has been discovered at Colorado dairies, and although paid a salary, they are generally tasked with the ability to make nothing more than small, insignificant decisions with no real authority. And that's not really consistent with the meaning of the exemption. So I would ask for an aye vote on L14.
Further discussion, Senator Pelton.
Thank you, Madam Chair. I rise in opposition to L14. You know, this is so similar to some of these other amendments that have failed. We're just, instead of calling it potato, we're calling it potato. There may be 1 or 2 operators out there that are skirting around and doing this, but the agriculture community is a very trustworthy community. They give you a title, a job, they mean it. And those people take that seriously. So I rise in opposition to L14.
Is there further discussion? Senator Liston.
Thank you, Madam Chairman. Well, members, let me just kind of read you for the millions of people who are watching, as well as some of the people in our audience. what the definition is of livestock employer. It means an agriculture employer that is engaged in the raising, feeding, and caring of livestock animals such as cattle, sheep, swine, horses, bison, poultry, and similar animals for commercial purposes. Well, members, I will confess to you, I'm a city guy, and I was not raised on a farm, but I highly respect and appreciate the hard work that the people who run farms and ranches. Far be it from me, somebody from the city, telling a farmer or rancher how to run their business when they've done it successfully for years and generations. I don't think that we should be telling the good people in rural Colorado, be it on the eastern plains or the western slope, and the ranchers and farmers that live, eat, and sleep and die agricultural work. I don't think it's our job to be telling them how to run their business. I would urge a no vote on Amendment L014.
Further discussion? L14. Seeing none, the motion before the body is the adoption of L14 to Senate Bill 121. All those in favor say aye. Aye. Opposed, no? No. The noes have it. L14 is lost. To the bill, Senator Cutter. Mr. Schaffler, will you please read L18 to Senate Bill 121?
Amendment L18.
Senator Cutter.
Thank you, Madam Chair. I move Amendment L18.
To the amendment.
So this requires CDLE to conduct outreach to ag employees and employers to educate them on the changes in the bill. In the committee, the mention of CDLE rulemaking was eliminated from this bill. However, in current CDLE rules, the ag overtime threshold is set at 48 and 56 hours, depending on the season. So this is going to create a lot of confusion between what's in statute and law. CDLE needs to be able to conduct outreach to impacted workers and employers to educate them on these new standards. This outreach includes visits to employer-provided housing sites and other residential facilities where ag workers reside. Workers must be well informed on their rights and how to file labor violations, which is included in this amendment. I think this is very reasonable. If we're going to change things so dramatically, it feels like workers ought to have the opportunity to know. And we hear all the time that people aren't aware of the laws and the things that we pass. So I think this is a good measure to help protect workers.
Senator Rodriguez.
Thank you, Madam Chair. Colleagues, I urge a no vote on this. While I appreciate the conversation, if any of you have run a business, this is always something standard. You have to, as an employer, put up a wage and hour step poster that they change every year in your workplace. As we're talking about fiscal constraints, we had to do work to take the fiscal note out of it. That's why we took the current practice. The bill we have now is just switching the 48 to 56. We amended the bill back to the 56. We don't need to incur a fiscal note to do those changes. All this bill does is to create a fiscal note. Ask for no vote.
Further discussion, Senator Kirkmeyer.
Thank you, Madam Chair. I would just say this. For those of us who know and have been in farming, we already know that the Department of Agriculture already does this. So it's not necessary. And from the Joint Budget Committee, no fiscal notes, folks, no fiscal notes. This would drive a fiscal note. Urge a no vote.
Further discussion on L18. Seeing none, the motion before the body is the adoption of L18 to 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L18 is lost. To the bill. Senator Wallace.
Thank you, Madam Chair. I move L19.
You have to get the amendment.
Oh, cool. Mr. Schaffler, will you please read L19 to 121?
Amendment L19, strike the Business, Labor, and Technology Committee report dated March 19, 2026. Amend printed bill, page 2, lines, strike lines 4 and 5.
Senator Wallace.
Thank you, Madam Chair. I was just getting a lesson from the majority and minority leader about what to do next. I would like to move Amendment L019 to this bill.
That was, to be clear, y'all, that was my error, not yours. So direct all here. At any rate, Senator Wallace.
Thank you, Madam Chair. This amendment requires the Agricultural Workers Advisory Committee to review and issue an advisory opinion on potential impact of this legislation onto ag workers, employers, and the agricultural industry as a whole before it can be implemented. The Agricultural Workers' Rights Act created the Agricultural Work Advisory Committee to gather and analyze information regarding the wages and working conditions of our agricultural workers. This committee is composed of workers themselves, advocates, and representatives of the agricultural employers. These experts should be consulted on legislation like this that specifically impacts agricultural workers and their wages. And a thorough review and advisory opinion can help guide the actions of our Agricultural Workers Service Program to ensure that our workers and employers are notified of changes and that the legislation is being implemented as needed. So I ask for an aye vote.
Okay, but you said you would like to move it. Did you actually move it?
Oh, I move it. I move Amendment L19, ma'am.
I'm going to gavel myself because that was a proper motion. All right, L19 has been properly moved.
Great.
Is there further discussion on L19? Senator Rodriguez.
Ask for no vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of L19 to 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L19 is lost. Is there further discussion? Senator? Mr. Schaffler, will you please read L8 to 121?
Amendment L8, amend the Business Labor Technology Committee
Senator
report.
Cutter.
Thank you, Madam Chair. I move Amendment L008.
To the amendment.
So this reinstates CDLE rulemaking from the introduced version of the bill because we believe CDLE needs the authority to be able to promulgate rules when a labor standard is changed. The language in the bill is currently too vague around what types of family members of farm employees are exempted from overtime. It's also too vague around what it means to be a decision-making livestock manager, and CDLE really needs to be able to define these folks, so we would ask for an aye vote.
Is there further discussion? Senator Rodriguez.
Thank you, Madam Chair. Again, trying to generate another fiscal note, ask for no vote.
Is there further discussion? Seeing none, the motion before the body is the adoption of L8 to 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. My apologies. And L8 is lost.
Yeah.
Mr. Schaffler, will you please read L15 to 121?
Amendment L15.
Senator Cutter.
Thank you, Madam Chair. I move Amendment L15.
To the amendment.
So CDLE must provide written notice to ag employees on the new overtime standard. Workers deserve to know about labor standards that impact them, especially if they're being rolled back. Workers also need to know how to file labor violations. Information around that must be included in this notice. These are workers that are sometimes not English speakers, and so to the degree that we need to help them understand and be able to file these labor violations, and it needs to be available in English and in Spanish. The notice also must be posted on CDLE website. And this amendment is just about informing workers of their rights, not of the change, but of their rights.
Further
And
discussion.
we would ask for an aye vote.
Further discussion on L15. Senator Simpson.
Thank you, Madam Chair. Again, I rise in opposition to L15. Largely, the demands in this amendment are already covered either annually through labor employment laws, posters, and/or education outreach from the Department of the Department of Agriculture, Farm Bureau, Rocky Mountain Farmers Union. They're all active in this space and making sure employees are well informed. Ask for a no vote.
Further discussion on L15. Seeing none, the motion before the body is the adoption of L15 to Senate Bill 121. All those in favor say aye. Aye. Opposed, no. No. The noes have it. L15 is lost. To the bill, Senator Marchman.
Thank you, Madam Chair. So I appreciate this conversation. I appreciate I've learned a lot today. But I would say that I still have some questions about ag overtime pay. So with that, I'm going to move the final amendment.
There's an amendment at the desk. Mr. Schaffler, will you please read L16 to Senate Bill 121?
Amendment L16.
Senator Marchman.
Thank you, Madam Chair. I move L16.
To the amendment.
Okay, so appreciate this. What this would do is it would require CDLE to conduct a study of ag worker overtime pay before the bill can be implemented. This study would include the number of workers who received overtime since it was instituted, how many of those who received overtime worked for seasonal employers, the number of seasonal employers versus year-round ag employers. So no significant data really exists that shows the impact of the overtime pay rules that reached the end of a 3-year phase in period 2025. Changes to wage laws should be based on economic data, not anecdotal evidence from employers. Rolling back ag workers' overtime without a study undermines the thorough rulemaking process completed by CDLE in 2022. The USDA is no longer producing the Farm Labor Survey, which also creates a gap in data about farm worker wages. I tell you guys all the time, data is my love language. So here's a way we could go get some data before we implement this bill. I ask for an aye vote on L16.
Language access in multiple levels. I appreciate it. Senator Kirkmeyer.
Thank you, Madam Chair. I appreciate that last week we had forecasts. We're anywhere from $1 billion to $1.47 billion short. Requiring a contract between the Department of Labor and Employment with the Institution of Higher Education to do a comprehensive statewide study would be a fiscal note. I would ask for a no vote on this.
Is there further discussion on L16? Senator Rodriguez.
Thank you, Madam Chair. In the hearing, we had shared data from Berkeley, and we had testimony from somebody at the CSU Ag Department that didn't come out in position of the bill or not, just reflected how that survey and the data from California could apply to us as well, that this actually does reduce wages for workers.
Is there further discussion on L16? Seeing none, the motion before the body is the adoption of L16 to Senate Bill 121. All those in favor say aye. Aye. Opposed, no? No. The noes have it. L16 is lost. To the bill. Seeing no, Senator Catlin.
Thank you, Madam Chair. Members, I'm here today to talk about something that we haven't talked about yet. We've talked labor, we've talked management, we've talked as though there are silos between the management, the owners, and the labor. Nothing could be further from the truth. The farms and ranches that are represented here today and that are represented by those of us down in the well are places that people live and work for decades. I'm sure that if you asked any one of these owner-operators, you would find that there are examples of people that have worked for them for 20 years and longer. So I wanted to share something with you that I haven't really talked about in regards to the way things work on farms, particularly, because I'm from a farm. When we started talking about the ag labor bill and all, I made mention that we had men on that farm that had been with me for 28 years, and 17 and 18 years, that their children have been born on that farm, that they've been raised on that farm. But I don't think I've ever talked to you about the feeling that goes between those of us who are owners, operators of these outfits. We had a man named Felix that had been with us for 28 years. I mentioned that earlier. My mother passed away, and my dad asked him if he would be a pallbearer for my mom. And he said yes. 3 or 4 years later, my dad passed away. And I went out to the shop and asked Felix if he would be a pallbearer for my dad. And the man broke down in tears. And I kind of had to hold on to him because he knew that his family had passed. And he knew that the only last job he could do for my dad was to be one of his pallbearers. You know, I think sometimes folks don't get an opportunity to feel how deep those feelings are between people that you have known and loved for years and years, until you see the look in their eye when you ask them if they would be a pallbearer for your dad. And those men stood there at that grave and they cried like I've never seen men cry. And it wasn't because the guy had been abusive or that he had taken advantage. The man had taken care of them and they'd taken care of him. You know, we've, on that farm, have had 10 or 12 families that have become citizens of the United States because they work for this outfit. And it would have been easy to not do that because it's expensive and it's time consuming. But these people had been so much part of that family that they needed to be citizens of this country. And the only person that could do that was my dad and my mom. And they did. The man that I'm talking about, Felix, is today a citizen of this country. And he is very proud of that. And he's very proud of the fact that my dad loved him enough to do that. To this day, he's still attached to that farm in one way or another. So when we get into these arguments and these debates and these kind of things, I think we need to think about the human aspect between us and the people that we associate with day in, day out for dozens of years, for decades, for multiple decades. What is that feeling? It's not one that you would ever take advantage of someone. It's not one that they would ever take advantage of you. There's a sense of loyalty and a sense of family that if you've never experienced it is something that you would probably be very proud to have that feeling about people that may be from a completely different culture that bring homemade food to your house because they want you to have some. They want to celebrate Christmas with you in a way that only they can do. You cannot pay for that. No matter what we say and do here in this building, you cannot pay for those feelings. Those feelings grow because of the way we treat one another. And I think one of the things that the state of Colorado should be a lot more aware of is the feeling that agriculture has for the people that help them on those farms and ranches. The feeling of family, the feeling of needing each other and depending on one another and celebrating the good harvests and work hard on the times like we're heading into now that are going to be very, very tough. That's not just on the employer or the owner. It's on the people that live on those farms and that help with those farms, that grow those crops and grow those animals. So I'd ask you all to just simply keep in mind, we're talking about people, we're talking about people that employ people, but we are not here to take advantage of them because we need them badly every day. Thank you.
Thank you, Senator Catlin. Further discussion on Senate Bill 121. Senator Sullivan.
Thank you, Madam Chair. And it's been an interesting discussion. I know, with all of the talk and stuff, you may have missed some of the things that were said. I kind of pride myself at paying attention. And what you heard was from one of they said that Senate bill, the bill in 2021 probably never should have been passed. Was one of the statements that was made. And that's really what the crux of this all is. The bill in 21 was passed. The people in this chamber and the other, and the governor signed into law Senate Bill 21087 that gave these workers finally their opportunity to be a part of the work process with everybody else. And they wanted to talk about how it's a 24/7 and no one else understands that. I worked at the United States Postal Service for 27 years. The mail never stops. Our people are there every single moment that a light is on in that building. I'm not going to compare it to sheep herders, but you can imagine supervisors are corralling the workers from the smoke break areas and from the coffee machines back to their machines so that they process the mail. And it continues to come. So I know what it's like. My coworkers know what it's like to work in a facility, in a place that's 24/7. And we were pleased to be a part of the bill in 21 that allowed the people who were out on the plains, on the frontiers, doing work the same, but in a different way that we were doing it. And we were incredibly supportive, and we continue to be supportive of them today. I mean, that's why we had a counter bill that disappointingly failed in that committee, and this is the one that they came forward with. And it just moves it back to 56 hours. I mean, I can tell you about, at the post office, getting paid double time. I can tell you about getting night differential, getting holiday pay. That was all things. And they're still, and that's an industry, quite frankly, that's losing billions of dollars a year. But it is a service that is needed, and we as a community, we as a country, I mean, again, it's written into our Constitution that we have the mail service. This is something that we need to work out. People need to be paid. People need to be cared for. And I thought what we had done in 21 was a way forward with that. I'm disappointed that we are trying to claw back from that with, once again, the tactics where everybody's going to leave the state if something like this were to happen. Things are changing. This needs to change as well. I'm sorry, but I cannot be supportive of this, but I will forever be supportive of all of the workers here within our state, whether they work in the urban setting, in warehouses like I did, or they work out on the plains, or up at 10,000 feet herding sheep. I support all of them.
Thank you. Further discussion from Senator Kipp. Oh, sorry, Senator Rodriguez. I have a cue.
Thank you. I kind of bumped the line. Thank you, Madam Chair. I'd like to thank my colleague, for the good senator from Sentinel. I don't disagree with the things he said. I don't look at this bill as I'm trying to hurt workers. I'm trying to balance an industry that's under different conversations. I have family who worked at the bulk center. I've had these conversations with the good senator. I get that. The work never ends. And I've always been trying to be a balanced approach. I supported the bill. I came to this well and fought for it. I came to do it. We as legislators run bills all the time that we have to come back and make tweaks or adjustments on. We have a bill that I think it was Senate Bill 4 that we did an adjustment on from the previous bill that we amend and change and tweak or expand. This bill did have rulemaking. I supported that bill. Data showing that it's not helping. The post office absolutely has problems, and I do get that. I also see that they have the ability to they're looking to raise their prices to keep working. This is an industry that doesn't have that tool. This is a structural problem. I get it. We could let them raise prices here in Colorado. Do you think anybody would buy their product and it would generate work? If you don't have business to have workers, you don't have workers. If you don't have businesses that we always sit up here and blow up the corporate, I was like, yes, I do get there are people that abuse the system. I am a small family business owner. I have 40 employees. I know their names and I care about them. They are not a massive corporation that are numbers on a spreadsheet that I can cut easily. I know who they are. We do work. We give them health care. We pay their health care. We give them bonuses, holidays. You know, we try to do everything in that. And that's what, if you want to see the decimation of industry and saying they're going to leave, the small family farm, which is 80% of our industry, is a thing that we should be proud of. If you want to see us turn to California, where it's all corporate farms and big money, and then also the discussions we're having of automation, that's how it works. You go, even in Colorado, go to a store, go to a bank, those systems are being automated because of the cost of labor. I don't know if this bill will be the single issue that will fix it. We have water issues, we have climate issues, we have many issues we have to deal with. This bill is not going to solve those problems. It's just a discussion we're trying to have where you have data. We had workers come and testify that they calculated their hours, even when they make their money in the bulk season, the grow season is why they come here to work. They calculated their hours for the year. They did 2,000 hours. They didn't even do the 2080 required. That is the industry we're dealing with and trying to address those needs and how that works. To sit here and pose our urban values on an industry we don't know and rate. I went out and talked to the farmers. I went out to the communities. I went to an onion plant. We should not impose what we think is right. They're asking for it. Workers did testify in support of this bill in committee. I just want to recognize that.
Thank you, Senator Rodriguez. Senator Kipp. Followed
Thank-
by Bright, Benavides, and Weissman, and anyone else who wants to join the stack. I just realized I have a queue going and want to make folks aware of it, so I'll keep adding folks to the stack. With that, Senator Kipp.
Thank you, Madam Chair, and I really appreciate everybody's thoughtful discussion on this topic today. It's a really hard one. I voted for the act back in 2021, and I know there were people who felt like the overtime threshold was too high and others who felt like it was too low. And, you know, I'm not in your shoes. I don't work a farm, but I do understand that you are facing pressures, but I also understand the pressures of the workers and the need to not be overworked. My understanding is also that there are workers who are on both sides of this, and that is, you know, what brings me to my answer that I know there's some workers who would say, yes, give me more hours because, and I'll work at the same rate because you can't pay me, but there's also workers who are saying, you need to allow us to get overtime because we are working, it is hard, tiring work, and that is what brings me to my vote respectfully of a no today on this bill. I think that people should deserve to be paid good wages for their work and overtime when they exceed a certain threshold. And my belief is just that this threshold is too high. So thank you for allowing me to weigh in on this debate.
Thank you. Senator Bright.
Thank you, Madam Chair. Rise in support of Senate Bill 121. I currently live on a farm. My first job when I was a teenager was working on a farm. It's probably my second favorite job right next to this one.
Yeah, you have to say that.
I also learned a lot on that first job. I was tasked with, as a teenager, milking 120 cows a day, twice a day. My first job, again, I was a teenager, and my shift was 2 a.m., milk 120 cows, finish at 9 a.m., go get something to eat, take a nap, come back at 2 p.m., and again milk the same 120 cows till 9 p.m. Go home, grab some sleep, go to school the next day, have a day off, and then come back the following day and do it all over again. So one day at work, one day at school. That was what I did. Bought my first car as a teenager, and I loved the freedom and the work and the responsibility that was given to me, and I learned so much from that experience. And I'm thankful for the family farm folks just 3 miles away that allowed me to have that job and work those hours and do that. I got paid $25 to do the morning shift, and I got paid $20 to do the afternoon shift because there was some feeding and scraping of corrals in there every day in one of the shifts rather than the other. And I never questioned it. I never asked why. I never said I'm being treated unfairly. I was a teenager. I didn't know. I was just thankful for the work and thankful for the independence. And so as we're looking at this bill, as we're looking at an exemption for the agriculture industry, I just wanted to know why is it that the ag industry is exempted from overtime and potentially from minimum wage? And the answer is pretty simple. Agriculture workers are exempt from federal overtime pay based on the Fair Labor Standards Act of 1938. That's nearly 100 years ago this thing was passed. And why? It was due to the historically seasonal, unpredictable, and weather-dependent nature of farming. You put sheep, you put cows out on the pasture in the summer. You don't do that in the winter. You milk cows at 2 a.m., not just whenever you feel like it or whenever you're not going to get paid overtime for it. It has to be done. It's seasonal. Seasonal daily, seasonal yearly, monthly, seasonal all the time. And if farmers have to dance around this, it makes it overly difficult for them to get through their planning process. Our perishable crops, things need to be done to protect our crops from perishing. We need to get that work done quickly. Historical precedent. This law has been in place since 1938. Yes, it's had some adjustments here or there, but sheep didn't change, cows didn't change. They still have to be milked 2-3 times a day. That hasn't changed. It's funny how nature doesn't change in that way. And so I also looked at a fact sheet that was put out by the Wage and Hour Division of the U.S. Department of Labor talking about FLSA. Virtually all employees engaged in agriculture as it's defined under the FLSA are covered by the Act in that they produce goods for interstate commerce. You have primary agriculture, you have secondary agriculture, they have different rules, all based on the seasonality of the agriculture industry. There are certain exemptions under FLSA that do not require specific employees engaged in agriculture to be paid overtime pay or a certain wage. The employee's exempt status is contingent upon the duties that the employee performs each work week. Thus, whether an employee is exempt from the FLSA or not is assessed on a work week basis, and each work week is assessed independently of other work weeks. This is a 50-state nationwide labor law. If we start changing that in the state of Colorado, and I've heard the arguments for and the arguments against, we have sheep and cows grazing in Wyoming, in New Mexico, in Utah, Nebraska, not far from here. And if we make it overly difficult for our ag producers, our job creators, to create jobs in the state of Colorado, they won't have a choice but to just move their operation across the state line. I don't want to see that happen because I love seeing agriculture in our state. I'm not saying it will happen, I'm not saying it won't, but the more we stack cards against our job creators, the more they want to move out of this state. Look no further than Palantir. Just took a huge operation out of Colorado. And why do they do that? They do it because of the onerous regulations that continue to come from our legislature to drive them out. And I know we're working in the best interest of components and things in the operations of those businesses, but we need to take a look at the overall impact of what we're doing, what we're producing out of here, and we need to make sure that we're competitive as a state with our neighboring states so that we don't continue to lose more job creators and more of our workforce to other states. With that, again, I would encourage an aye vote on Senate Bill 121.
Senator Benavides.
Thank you, Madam Chair. Members, I was here in 21 when we debated. In the House, we were here until the early hours of the morning debating this bill. There was lots of amendments to get to the compromises that we got, that we have been under for 5 years, even all of our agricultural businesses. So we've worked through this. I'm not supportive of this bill. I also wasn't supportive of the bill to make it 40 hours. Because right now, and since 21, agricultural workers have been eligible for overtime if they work 48 hours. And for seasonal workers, seasonal agricultural businesses, at the height of that, if they double their workforce, if they do it for more than, I think it's 22 weeks, they would be eligible to only pay overtime at 56 hours. And I think the bill that the sponsors have brought would make it 56 hours across the board. And that sounds great, and they don't have to do all the record keeping, except for those other agricultural workers who don't do seasonal work, that go in every day and do their job. Right now, they're eligible for overtime after 48 hours. That'll be raised to 56 hours. So that can hurt them. And I don't think we should hurt somebody in that place if we're trying to make businesses better. Why should we hurt those workers? And that's primarily why I'm on a no on this bill. I would rather allow the status quo of 48 hours until there's a seasonal need that it goes up to 56 hours. That's what we have right now. And I think it has been working. Yes, there's complaints because right now, not only us here in the urban areas, but in the agricultural areas, the issues with buying groceries, feed, fertilizer, everything is going up. And it's hard to make a living in this business. And I think we recognize that. I think that every worker has dignity in the work they do and should be respected. But if we pass the bill as it's been amended, there is a group that's going to be hurt. That's the group that works regular job, not seasonal, and they're entitled to overtime at 48 hours. They're the ones going to be hurt because now they're not entitled to overtime until they work 56 hours. So I would rather keep the status quo. That said, I'm going to be a no vote on the bill, but I do want to say something about this process. You know, sitting at my desk and watching what was happening, since I've been here, this is the first bill that has gotten the debate that it deserves from both sides of the aisle. I think both sponsors and both sides of the aisle should be proud of the work they've done on this bill, because I think this is how we should be doing things. It's about the policy, it's about the people impacted. So even though I'm not where the sponsors want, I think the work that's been done by everybody here has been really good. So that said, I encourage a no vote.
There's a reason we're called the upper chamber. There's a reason we're called the upper chamber. Thank you. Senator Weissman.
Thank you, Madam Chair. Just briefly, since it's been put into issue on the subject of how laws intersect with employment decisions, in 2025, Florida passed a law that was shorthanded to the Choice Act. I believe it was Senate Bill 922. It was some very employer-friendly ability to enforce non-compete provisions against skilled, highly compensated employees. That's why Palantir left to take advantage of those laws. We've got, I think, a lot more pro-employee provisions in Colorado. That's happened since I've been here, and credit to those who did that work. Some of the states with the best non-compete laws are all over the map. They're California and North Dakota, believe it or not. So just to clear up the record on that, I think like the Palantir of Tolkien lore, you need to be careful gazing too deeply into that, because the stone can be bewitched and it will show you what it wants you to see and not what is the truth. But like some other senators have mentioned, I was here too for SB 87. I remember that debate. It was hot. It went on for hours. And just so everyone's clear, you know, we're not starting from a starting point of 40 hours like most other hourly workers. We have this bifurcated structure pursuant to that exhaustive rulemaking. Some agricultural workers get overtime after 48, some at 56. Already, workers in this sector are not treated the same. I do believe that the sponsors earnestly care about agricultural workers, and I believe that others have spoken do. I've looked at some of the papers that were handed out by proponents of this legislation, opponents of the other one. Short takes by economists looking at incentives created in the law, incentives for employers to behave a certain way at a certain number of overtime hours. I think where I come down, though, is I just think a little bit more about the individual worker as opposed to the collective. I think the collective view is that, well, you know, if we don't have a higher than 40 cut point, demand for labor will shift. Some folks may be less well off. They may want to work more, and so on. Where I start from and where I think I end on this policy is simply the idea that the worker should be viewed as an individual, and that we should try to keep closing up, or at least not widen this difference that we've opened up in the law. Again, the non-passage of this bill doesn't mean 40, it means 48 or 56. And to some of the comments that have been made, I believe that a number of agricultural workers would rather work 56 or 60, maybe more hours before overtime triggers on, frankly, given the plight of some of the nations that they have fled from and sought, for example, an H-2A visa to come here. I've traveled to Peru, I've traveled to other Latin American countries. Those folks haven't been as fortunate in their history as we have been. So they come here, and sure, maybe they'll work 60 hours if that's what's on offer, because they just want to grab a little sliver of this vanishing thing that we call the American dream through hard work. I think, though, where I'm hung up is, does that have to be the question? 60 hours or nothing, 56 or nothing? Is that the limit of what we can imagine, what we can construct by way of economy and society? Not anywhere, but in this privileged country, this economic superpower. I was just checking the Forbes list. 9 of the 10 richest people on the Forbes list globally are in this country with a wealth estimated at $2.3 trillion. And then as to the folks who have done this work that we talked about all morning, the brutal work of harvesting crops, of tending animals, they just passed it, but they were on it for a long time. There is a resolution in the House to change the name of Cesar Chavez Day to Farm Workers Day. I think we all know why. Farm Workers Day, because that's really the point. It was never about the person now revealed to be quite flawed who led that effort. It was about the people doing the work who deserve the dignity that they weren't getting. So even as we rightly rename that holiday in honor of those who do the work, we're sort of grappling with a fight for crumbs over here. I've been thinking this morning about that famous William Jennings Bryan speech from 1896. You shall not press down upon the brow of labor this crown of thorns. Now, he was talking about the gold standard and whether money would be tight money pegged to gold or looser money pegged to silver, and whether creditors or debtors benefit from that. We're not talking about that now, all right? We've been off the gold standard since 1973, but I can't help but think lately, whoever else might be getting the rose, that too often working people are stuck with the thorns. So at the end of the day, I think I'm just sad. I'm sad that we're here, that I know why the bill is coming. I've read some of the supportive materials, but I'm sad that in this land of richness and power, we are nonetheless coming from an economics and a policy of scarcity. So I have to be a no.
Senator Pelton R.
Thank you, Madam Chair. I rise in support of Senate Bill 121. Is it the bill I want? No. The good senator from Aurora just talked about this land of economic prosperity in this country. The grain farmers in America the last 2 years are operating in the red. They are taking some of their reserves, some of their equity out of their land, out of their equipment, just to survive. I guarantee you any ag laborer on that place is making more money than the people that own that place. The good senator from Montrose talked about the human factor. I have businesses that live in this space. Those are people that work with us. But for them to have a job, we need to be profitable also, without burning up all the equity out of our land where we cannot pass it down to the next generation. Agriculture is special. It's different for a reason. I thank the sponsors for working on this bill to try to correct some of that injustice that was done in 21. Do I think it's there? No. But it's a step forward. There's a lot of party line policy comes out of this building, and it's bad policy. This is helping to correct at least a portion of some of that kind of policy. So with that, I rise in support of 121.
Senator Cutter.
Thank you, Madam Chair, and thank you all for listening to the debate today and for all the work everyone has done. I just can't help but reflect on the good senator from Aurora's words about being a prosperous nation. And here we're talking, I know and acknowledge that many of you have a hard time. I don't think farming is an easy life by any means. And I hope you know and understand that. But we can't put things on the backs of workers. And I feel that, we live in this nation that is the wealthiest nation in the world. And we're talking about middle-class farmers and workers. The wealth is concentrated so far at the top that we're not even, and we're arguing about things that people's daily lives and getting by and feeding their families. And I wish we would all be able to take a step back, and not that we could do anything about it, but look at where the wealth is really concentrated and what we're all facing as citizens in this country right now. And yeah, thank you for all the work you've done on this, and that's all.
Further discussion, Senator Simpson.
Thank you, Madam Chair. A couple of thoughts come to mind. One, it's National Ag Day. what a great opportunity. And there might actually be people in the building, maybe from the Colorado Seed Potato Committee and or Colorado Farm Bureau or Rocky Mountain Farmers Union that are going to feed us today at lunch. And what an appropriate time and opportunity. A couple other thoughts. The good senator from Aurora talked about the sadness of today. I'm actually quite the opposite, to be very much optimistic that maybe this is an opportunity to create, again, it's cliche, but a true win-win situation where under the path we were headed down, and truly if we went to 40 hours, you were going to see a decline in the number of ag workers in the state of Colorado. I think where we've landed is a good balance that, again, does create having a valued, respected workforce, and certainly incrementally a little more healthier, profitable set of producers, which is key to our success in this space. In Colorado, there are about, based on the last Census of Agriculture, there are 36,000 farms in Colorado. Less than 5% of those, about 1,800, have revenue of over 500,000. So the dominant conversation in this state about agriculture are small family farms and operations. I think about historically, I'm the fourth generation of my family to farm and ranch in the San Luis Valley. My grandfather raised his family on 160 acres. My dad raised our family on like 500 acres. I'm telling you today, I have a 800-acre irrigated farm that if I didn't have this job and manager of the Rio Grande Water Conservation District, I couldn't raise my family on 800 acres. And then a lot of it goes into that about how much debt you carry and equipment and input costs. But this policy, this bill is really targeted and helpful in that space of how do you get these small farms to just really, I characterize it as just hanging on and being part of the ag industry. Somebody had referenced, the majority of you referenced, I don't want to see us shift to large corporate mega farms across the state of Colorado. There's such value and such caring. The good senator from Montrose was really deep into that conversation about the connectivity across all of these small farms between the operator, the owner, and the workforce. That's not the exception. That's generally the rule. Without a doubt, there are bad actors, but I know so many producers that go above and beyond, they pay much more than minimum wage. They provide housing. They provide transportation, not just while they're on work on the farm, but they get to use for their personal use as well. Cell phones, bonuses, Christmas gifts, the list just goes on, that from what I see, that really represents what the standard is for, particularly in the small farm ag space. So it's been a great conversation. I was going to recognize the comments of the good senator from Adams County, I think. She's not on the list yet, so I'm going to say Adams County and how this debate and how this chamber functioned today. Very proud to be part of this conversation, and for me, what is such an important policy consideration, and encourage you all to support Senate Bill 121. Thank you, Madam Chair.
Is there further discussion on Senate Bill 121? Seeing no further discussion, the motion before the body is the adoption of Senate Bill 121. All those in favor say aye. Aye. Opposed, no? No. The ayes have it. 121 is adopted. Majority Leader Rodriguez.
Thank you, Madam Chair. I move the Senate proceed out of order, take up House Bill 1099.
You've heard the motion. All those in favor say aye. Aye. Opposed, no? The ayes have it, and we will proceed out of order to take up House Bill 1099. All right, everybody, take a deep breath. Let's go. Mr. Schaffler, will you please read the title to House Bill 1099?
House Bill 1099 by Representatives Titone and Wynn and Senators Colker and Marshman concerning protecting the financial condition of common interest communities.
Senator Colker.
Thank you, Madam Chair. I move House Bill 261099.
To the bill.
To the bill. Colleagues, this bill's purpose here is quite simple. It is to make sure that a reserve study is done for HOAs in new builds, for construction in new builds only right now. So That reserve study will help them determine the HOAs, how much they need to save for deferred maintenance. That's the purpose of this, so that the HOAs aren't underwater over time. I mean, that's the big purpose, and I'll let my co-sponsors talk about the rest.
Senator Marchman.
Thank you, Madam Chair. And yeah, so when a family buys a home in a condo or a planned community, they make one of the largest financial decisions of their lives. And in Colorado today, they can do that without knowing what costs are going to come later to maintain the building that they just bought into. So roof replacements, parking structures, there's no 30-year picture of what the association they're joining is financially prepared or unprepared to handle. This bill changes that. It requires developers to commission an independent 30-year reserve study before the first unit ever sells, and then it puts the study in the hands of every buyer 24 hours before they close. It requires the developer to transfer that study to the homeowners association at the point of handover. And it closes a real documented gap in how management companies handle association records when a community changes hands. This is an affordability bill as much as it is a consumer protection bill. The single most predictable cause of a surprise assessment, a $10,000 or $15,000 bill that lands in a condo owner's mailbox with 90 days to pay, is an association that never funded its reserves. Those assessments price people out, they foreclose, they destroy the financial stability of communities that were never told what they were getting into. I ask for an aye vote on House Bill 1099.
Further discussion? Seeing none, the motion before the body is the adoption of HB 1099. All those in favor say aye. Opposed, no. The ayes have it. That bill is adopted. Majority Leader Rodriguez.
Thank you, Madam Chair. I move to lay over the balance of the calendar until Wednesday, March 25th.
As always, a proper motion. You've heard it. All those in favor say aye.
Aye.
Opposed, no. The ayes have it, and we will lay over the balance of the calendar. Majority Leader Rodriguez.
Thank you, Madam Chair. I move the committee rise and report.
The motion is to rise and report. All those in favor say aye. Opposed, no. The ayes have it, and we will rise and report.
The Senate will come to order. Senator.
Thank you, Mr. President. We met and were wildly efficient and thoughtful and deliberative. Mr. Schaffler, will you please read the report?
March 24, 2026, Mr. President, in committee of the whole begs leave to report as had under consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. Senate Bill 128 as amended, Senate Bill 113 as amended, Senate Bill 121 as amended, passed on second reading in order to engross and place in the calendar for third reading and final passage. House Bill 1099 passed on second reading in order to revise and place in the calendar for third reading and final passage. Senate Bill 40, Senate Bill 134, House Bill 1144, House Bill 1071, Senate Bill 48 laid over until March 25, 2026, retaining its place in the calendar.
Senator Gonzalez.
See how wildly efficient we were? I move the report.
There is an amendment at the desk. Mr. Schaffler, please read S001 to Senate Bill 121.
Amendment S001. Senator Wallace moved to amend the report of the committee of the whole.
Senator Cutter.
I'd like to move Amendment S001 to the Committee of the Whole.
To the amendment.
So a 56-hour threshold sends the message that farm workers can be worked longer and harder than anyone else before the law steps in. That's unequal treatment, plain and simple. It would deny farm workers meaningful overtime protections and preserve an unfair second-class standard. When people have more time free from work, they can spend time with families and out in their community. Overtime protections help reduce income inequality and give workers more spending power to contribute to the economy. We all know that agriculture work is grueling, laborious, and often dangerous. All the more reason these workers should no longer be excluded from basic labor protections such as overtime pay for 40 hours. Overtime laws exist for two things: to compensate workers fairly for long hours and to discourage overwork. This 56-hour threshold undermines both of these goals. Today, Latinos disproportionately represent a majority of ag workers and are therefore disproportionately impacted by the current inequitable overtime threshold. Latino communities are being hit hard by the current federal administration and its immigration enforcement tactics. With Latinos representing a majority of agricultural workers, the industry is at high risk of adverse impacts due to these policy choices. These communities are living in fear due to the current administration, and rolling back overtime protections only puts more strain and uncertainty on these families. I ask for an aye vote on Amendment 001.
A Senatorial 5 has been requested and granted. Further discussion on S001 and Senate Bill 121. Seeing no further discussion, the motion is the adoption of S001 and Senate Bill 121. Are there any no votes? Senators Frizzell, Zamora Wilson, Kirkmeyer, Rich, Benavidez, Doherty, Amabile, Henriksen, Mr. Majority Leader, Mr. Minority Leader, Roberts, Snyder, Baisley, Lindstedt, Liston, Pelton B, Pelton R, Exum, Catlin, Mullica, Bright, Carson. Please add the president. With a vote of 11 ayes, 23 noes, 0 absent, 1 excused, S001 to 121 fails. There is an amendment at the desk. Mr. Schaffler, please read the title to S003 to Senate Bill 121.
Amendment S003, Senator Wallace moves.
Senator Wallace. Oh, Senator Marchman.
Thank you, Mr. President. I move S003 to Senate Bill 121.
To the amendment.
Thank you. So as we discussed, this is the decision-making managers. It eliminates the exclusion of decision-making managers from overtime exemption. This is where we're seeing a misclassification of dairy workers as decision-making managers, and we'd like to rectify that problem. So I would ask for an aye vote on S003.
There's further discussion. Mr. Minority Leader.
Thank you, Mr. President. We had good conversation about this in the committee of the whole meeting. I request a no vote on S003.
Further discussion on S003. Seeing none, the motion is the adoption of S003 to Senate Bill 121. Are there any no votes? Senators Rich, Mr. Majority Leader, Mr. Minority Leader, Benavidez, Frizzell, Kirkmeyer, Zamora Wilson, Snyder, Doherty, Lindstedt, Henriksen, Amabile, Pelton B, Roberts, Liston, Mullica, Baisley, Bright, Pelton R, Carson, Catlin. Please add the president. With a vote of 12 ayes, 22 noes, 0 absent, and 1 excused, S003 to Senate Bill 121 fails. Seeing no further discussion, the motion is the adoption of the committee of the whole report. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, the committee of the whole report is adopted. Senate Bill 128 is amended. Senate Bill 113 is amended. Senate Bill 121 is amended, passed second reading, order, gross place, count of third reading, and final passage. House Bill 1099 passed on second reading, order, revised, place, and count of third reading, and final passage. Senate Bill 40, 134, House Bill 1144, 1071, and Senate Bill 48 laid over until 3/25/2026 and retaining their place on the calendar. Consideration of House amendments to Senate bills. Mr. Schaffler, please read the title to Senate Bill 39.
Senate Bill 39 by Senator Snyder and Pelton B. and Representatives Basnicker and Taggart concerning the administration by the Fire and Police Pension Association of Disability and Survivor Benefits.
Senator Snyder.
Thank you, Mr. President. And we move to concur with House amendments.
Please tell us why, Senator Snyder.
Okay, now this is a truly legitimate technical change. There were two places discovered as it went through the House where they used the word shall, and that had to be changed. So literally, it is just a change of two words in the entire bill.
Further discussion on that motion. The motion is that the Senate concur with House amendments to Senate Bill 39. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, that motion is adopted. Senator Pelton B.
Thank you, Mr. President. I move for the repassage of Senate Bill 39.
The motion is the repassage of Senate Bill 39. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, Senate Bill 39 is repassed. Co-sponsors. Mr. Schaffler, please read the title to Senate Bill 84.
Senate Bill 84 by Senators Weissman and Frizzell and Representative Wilford concerning the preservation of privileges for certain state entities in connection with information made available to the Office of the State Auditor and the performance of its statutorily prescribed duties related to the state's fraud hotline.
Senator Weissman.
Thank you, Mr. President. At the risk of getting fined, I move the Senate concur with House amendments to Senate Bill 84.
Oh, man. Tell us why.
You know, it's a wild time when a bunch of lawyers get together and debate the finer points. The House struck two words from two parts of the bill in the interest of clarity, and I think we're okay with it. So we ask for a yes vote.
The motion is that the Senate concur with amendments to Senate Bill 84. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, 1 excused, that motion is adopted. Senator Frizzell.
Thank you, Mr. President. I move for repassage of Senate Bill 84.
The motion is the repassage of Senate Bill 84. Are there any no votes? What? Senators Zamora Wilson, Baisley, with a vote of 32 ayes, 2 noes, 0 absent, and 1 excused, Senate Bill 84 is repassed. Co-sponsors. Message from the House. Help. Help us.
The House has passed on third reading and returns herewith. Senate Bill 110. The House has passed on third reading and transmitted to the Revisor of Statutes. House Bill 1333. House has passed on third reading and transmitted to the Revisor of Statutes. House Bill 1331, House Bill 1332, House Bill 1183, House Bill 1109, House Bill 1308, and House Bill 1241, amended as printed in House Journal, March 23, 2026.
Message from the Revisor.
We herewith transmit without comment House Bill 1333, without comment as amended, House Bill 1109, 1183, 1241, 1308, 1331, and 1332.
Consideration of governor's appointments. Consent calendar. Mr. Schaffler, please read the appointments listed on the consent calendar.
Members of the Colorado Child Abuse Prevention Trust Fund for terms expiring November 7, 2028. Lindsay Spraker of Littleton, Colorado to serve as a subject matter expert with knowledge of child abuse prevention, reappointed. Antonio Chiesa of Denver, Colorado to serve as a subject matter expert with knowledge of child abuse prevention, appointed. Member of the State Board of Land Commissioners effective July 1st, 2025 for a term expiring June 30th, 2029. Deborah Frobe of Denver, Colorado to serve as a representative of Natural Resource Conservation as an unaffiliated, reappointed.
Mr. Majority Leader.
Thank you, Mr. President. I move for the passage of all the appointments on consideration of governor's appointment consent calendar, which are Lindsay Spraker of Littleton and Antonia Chesia of Denver for the Colorado Child Abuse Prevention Trust Fund, and Deborah Frobe of Denver for the State Board of Land Commissioners.
Is there any discussion? Seeing none, the motion is the confirmation of the appointments on the consent calendar. Are there any no votes? With a vote of 34 ayes, 0 noes, 0 absent, and 1 excused, those appointments are confirmed. Introduction of bills.
Senate Bill 146 by Senator Cutter and Representative Froelich concerning restricting the distribution of single-use food serviceware.
Health and Human Services. Signing of bills.
President has signed House Bill 1001.
Announcements. Senator Amabile.
Thank you, Mr. Chair. So guess what is happening today at 1:30? Can anybody guess? The Joint Budget Committee is meeting across the street.
Senator Kipp.
Thank you, members of Senate Finance. We will be meeting at 2 p.m. in room 357 to hear appointments to the Colorado Banking Board, also SB 26044, SB 261200, SB 261026, and HB 261120. We look forward to seeing you all there.
Very good. Senator Frizzell.
Thank you, Mr. President. Just in case you have a bout of insomnia, the Legislative Audit Committee is meeting tomorrow morning at 7 a.m. Yay! And we will be having a robust conversation, including an executive session, around the Governor's Office of Information Technology. I know. Very exciting. So please join us.
Senator Wallace.
Thank you, Mr. President. The Senate State Affairs Committee will be meeting at 2 p.m. today in the Old Supreme Court. We will be hearing 1084, 1133, and 1011. We will not be hearing 1088, which will be heard instead on the 2nd.
Very good. Further announcements. Senator Roberts.
Thank you, Mr. President. Colleagues, it's been noted a little bit, but I wanted to remind everybody that today is National Agriculture Day. It's also Colorado Agriculture Day. The festivities got started down in the West Foyer at 11:30. So if you have some time after this, head down there to get some good food, see the exhibits. Also head over to the East Foyer, where the Colorado Department of Agriculture has erected a mural celebrating the US 250 Colorado 150 anniversary, and the heritage and tradition of agriculture in Colorado is displayed in this mural. It's going to be there all week, but go down to the East Foyer when you have a chance to look at that. And the governor will be speaking at 1 o'clock to sign a proclamation for Colorado Agriculture Day. Everybody is welcome, and hope you can head down there and spend a few minutes with our agriculture producers from across the state. Thank you.
Very good. Does anyone know if Senate BLT will be meeting today? I was wondering if anyone from Senate BLT knows whether or not Senate BLT is meeting today. As I look at the person who might be the vice chair of Senate BLT right here in the well talking, is Senate BLT maybe meeting today at 1:30, 2 o'clock?
Thank you, Mr. President. BLT will be meeting at 2 o'clock at Senate Committee Room 352.
Very good.
To hear House Bill 1005.
By memory. Very good. Seeing no further announcements, Mr. Majority Leader.
Thank you, Mr. President. I move that the Senate adjourn until 9 a.m. Wednesday, March 25th, 2026.
The motion is that the Senate will adjourn sine die. No? All right. You've heard the motion to adjourn at 9 a.m. on Wednesday, March 25th. All those in favor say aye. Opposed, no. The ayes have it. The Senate will adjourn until 9 a.m. on Wednesday, March 25th, 2026.